Caribbean, joined by water, connected by culture, and linked by a common heritage.
We are here on Time to Face the Facts, looking at the ECSC, 50 years of the ECSC, the Eastern Caribbean Supreme Court. I'm Beverly Sinclair, and I have with me Ruggles Ferguson, Renee Batiste, and Anne Henry, QC, helping to go through this journey of the evolution of the court. And we were looking at the relationship between the court and the parliament and the matter of funding, which is the area where there is a serious issue that needs to be addressed in the court system. Insufficient funding, governments owing the court, not paying up, and the court having to find a way to continue its operations in this lack of funding. Ruggles, you were making a point. We were talking about the...
Well, on the issue of funding, and it relates to what the first caller and the last caller, well, the caller before the last indicated. Now, the CCJ has set up a trust fund to ensure the operation of the court, and that those monies, Caribbean governments injected $100 million into that court at the beginning. So the CCJ does not have to depend on Caribbean governments to fund it on a month-to-month basis, on a year-to-year basis. All countries, including Grenada, raised that loan from the Caribbean Development Bank and had to repay that loan proportionally. And most of the countries, if not all, have already repaid that loan. And the CCJ has set up now a trust fund, independent of governments, to manage that money. And it has been found to be a very effective system of financing the court. In fact, at the end of 2015, there was close to $90,000 still in that trust fund, even though the court was in operation for close to
90,000?
Yes, it was, I believe, about 88,000 at the end of 2015.
Isn't that trust fund supposed to have some millions in it?
So, well, 88 million, sorry, I said thousand. Sorry, my apology. 88 million. It started off with $100 million. And so that court is supposed to be funded based on the interest and so from the $100 million and investments done by an independent trust fund that is comprised of accountants, insurance persons, and so
and they were smart enough not to invest in Clico or Bico.
Well, indeed. So now what you have, there has been calls, there have been increasing calls, in fact, for the Eastern Caribbean Supreme Court to set up a system similar to the trust fund. Now, you know, this point about because Caribbean governments do not fund or pay for the institutions. In fact, it's notorious that many of these institutions, the University of the West Indies, the law schools in the region, governments are always in arrears. No. And therefore, we can't trust the CCJ because government would not pay their dues as normal. When this talk about the CCJ was since the 1970s, there was active talk about the CCJ.
Ruggles, we don't want to go too much into the CCJ and its structure.
Right, but the final point I just want to make about that, because the comparison with funding is that the bar associations, one of the preconditions for support of the CCJ as a final institution, one was independence for the appointment of judges, as we have with the Eastern Caribbean Supreme Court, Judicial and Legal Services Commission, and the independence of the funding mechanism based on the experience with the Eastern Caribbean Supreme Court. So,
and we managed to get on paper those two things put in place, but that's another story for when we meet, talk about the CCJ. I want to look at a significant event in the life of the ECSC in its 50 years, and that was the period when Grenada was not a part of the court. For about 12 years it was, Grenada was not a part of the court. Ruggles, perhaps you'd be the best person to explain how did Grenada come to be outside of that system and how it got back into that system.
Okay. The court was established in 1967, and for 12 years, until 67 to 79, the court was headquartered in Grenada. Then came the Grenada Revolution in March 1979, and the court, there's still debate as to what happened, whether the Grenada asked the court to leave or the court chose to leave because of the circumstances of revolution. But the court moved to St. Lucia to be headquartered. Now, one of the first acts, as you would find when there are revolutions anywhere in the world, is the suspension of the Constitution. And the Constitution between 79 and 83 remained suspended. Chief Justice Archibald Ned became the Chief Justice of our own court, and we then set up our own Court of Appeal in 79. And in fact, Grenada was said to have had the best Court of Appeal in the region during that period. Now, with the return of the Constitution in 1983, the part that dealt with the court system remained suspended, and remained suspended until 1991. I believe July 1991, when you had the Constitutional Restoration Act that restored the part of the Constitution that dealt with the court system. So between 79 and 91, in fact, between 83 and 91, far in excess of the life of the revolution, the portion that dealt with the court remained suspended, and we returned to the fold of the Eastern Caribbean Supreme Court in late 1991, early 1992.
You said something very interesting, that the jury is still out on whether or not the court chose to leave or whether or not.
Well, there are different views.
But the Constitution was suspended. The court was no longer wanted. So I don't think they had a choice on the surface of it. They didn't have a choice. They had to go.
Yeah. Well, again, that's a separate issue, a separate debate. But the fact, I'm just dealing with the fact.
Why didn't they? Why wasn't the court returned at the time when the Constitution was reinstated in 1984?
Well, and that has been a subject of litigation. In fact, in 1985, in the matter of DPP, Mitchell and the DPP, because the court was challenged, if you remember, during the Morris Bishop murder trial. Once the Constitution was returned, and the court remained the same court that the revolution established. The issue was it then constitutional to operate with a returned constitution with a different court system? That was challenged. And in fact, there's a case, the 1985 Court of Appeal ruling, which says, listen, the court has validity. It's unconstitutional, but it had validity on the basis of the doctrine of necessity.
Which had no end date, because that created major confusion.
Right, and the court advised then, the Court of Appeal, that Grenada return as quickly as possible to the fold of the Eastern Caribbean Supreme Court.
But it is said, and even the late Professor McIntosh wrote about this, that it was the court that actually decided, through then Chief Justice Flosak, if that's the correct pronunciation for his name, who wrote and said, the court does not want to have anything to do with this Morris Bishop murder trial, and it's not coming back to Grenada. And I'm putting this in layman's terms, and it's not coming back to Grenada until that trial is over.
No, it's not the court. The court wouldn't say that. It would be the governments at the time. They wanted to see, that was the official position, the completion of the Morris Bishop murder trial of the region, the Caribbean, the OECS governments, because it's not for the court and the Chief Justice to accept back Grenada as a member of the court. And Chief Justice Flosak would have been the Chief Justice at the time Grenada returned to the court system. The President of the Court of Appeal from 83, in fact, would have been G.O.F. Haynes from Guyana, a distinguished judge who, in that case, urged Grenada to return to the fold of the Eastern Caribbean Supreme Court because the Constitution was back and forth. So there's always that issue of debate about Grenada having a constitution and not having a court of the Constitution between 1983 and 1991.
And we have to take a break on that note. That is a topic which I think need to be ventilated a lot more.